Chair calls the House Civil Law Committee to order. Recognize the quorum. Representative Johnson, are you ready to proceed on House File 1994?
I am, Chair.
Okay. I know you just got here, so don't want to rush you.
Mr. Chair,
Representative Scott.
while we're waiting, do you happen to know the schedule, especially in the evening for next week? Are we going to be having some evening meetings, or what's that looking like?
You interested? I'd ask Committee Administrator Ms. Leffels to speak to that.
Representative Scott, we plan to have kind of a long agenda on Wednesday morning, and that will tailor off into the evening too. Not sure if we'll meet at 5 or 7:30. Depends on what rooms are available. I'm still trying to get a big room, so that's a problem. And then on Friday next week will be a long day.
Thank you.
Representative Johnson, it's my understanding that you have an amendment to 1994 as well?
That is correct.
Okay. And just briefly, what does the amendment do?
It gives some latitude for preparing for disasters like this coming fall or spring. With the amount of ice and snow we've had, I'm expecting probably some major flooding in the Moorhead area. This would give emergency management the opportunity and the ability, if they have the equipment, to pre-plan and monitor the flooding issues or a major fire issue during a drought, to prepare and place things and get things properly in place for an emergency.
Representative Johnson, which agency does this carve out an exception for?
Emergency management.
Okay, Representative Johnson, did they testify that they have drones now?
No, as far as I know, nobody has them, but if they should have some, or there's one available borrowed from another department, that would have them. If the Sheriff's Office or VCA or anybody would have one, given them the ability to use that without having to have a search warrant.
Okay, and Representative Johnson, members, we heard testimony also from MnDOT, which I was kind of confused about because MnDOT said, well, we don't have drones. And then I asked why she was insisting on usage, and she said, well, we might have them in the future. And normally, it would be the preference of this committee to pass the policies and resolutions as they apply now. And if there is an exception that needs to be crafted in the future, I think it would be appropriate. That said, I think Representative Johnson has been very accommodating for these caveats or provisos that might maybe happen someday in the future, which I think is probably a good thing to do. So with that, what's the amendment number? Okay. What is the amendment number on that?
Mr. Chair.
Representative Johnson.
Good. One more comment on that statement you were making. In Public Safety Committee, when MnDOT was talking, it could bring the cost from setting up in, I believe it was the Highway 210 flooding. Instead of costing close to $100,000, it would have cost them $6,500.
Well, and Representative Johnson, I appreciate that, and I heard that statement too. I was also kind of surprised at the testimony because, considering the fact they don't have one and they've never used one, I consider testimony like that speculative at best. I understand it could bring down the cost, but which of course is an incentive to do it, and this is a fact-finding committee, as are all committees. Therefore, we have to rely on what comes before us. That said, Representative Johnson moves the A1 amendment in order to get the bill in the shape the author desires. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. And the motion on this, if I failed to mention, members, is that it be referred to the Committee on Judiciary, Finance, and Policy. So, Representative Johnson, to your bill, as amended.
Mr. Chair, members, this bill deals with drones, or what law enforcement would rather call them is unmanned aerial cameras. I've talked to a number of sheriffs and police chiefs throughout the state. Some have contacted me, some I've contacted. And what they're looking for is guidance on how to use them. At this time, no departments have them, but the cost is dramatically coming down. I've seen them online for under $500. So they are looking at these for possibility of evidence gathering, for a search warrant, for grow operations, for officer safety. But before they do a search warrant, they can fly a unmanned aerial camera over the target area for people that are doing the entry can actually see a bird's eye view of what the property looks like to make sure that they do go to the proper house and not like what's happened a couple times doing a search warrant, kicking the door in and being in the wrong house. Makes it better for them to get to the proper house. They have an idea of who's going to be there, possibility of any traps, and it's all designed for officer safety on the search warrant aspect of it. They also want to have the ability to use them in searching for lost children or any adult. I myself have spent hours trudging through swamps for 2 days looking for a lost girl. It is not fun. When you're done, I had 2 sets of uniforms that I actually had to throw away because I could no longer get them clean. And the odor was not fun from going through the swamps. The other issue is for manhunts, where we have a fresh pursuit. I had a situation where the U.S. Marshal's Office and a task force I believe it was about 4 years ago, ended up in a pursuit. The gentleman bailed into a cornfield, and we literally had to commandeer the farmer's combine, an officer drive the combine, 3 officers on top of the cab looking for this person because it just was not safe for us to walk row by row down to search the field because we did not know if this person was armed or not. And there again, this can go back to officer safety and the safety of the public by apprehending this suspect hopefully sooner. So what the sheriffs are really and the police chiefs are looking for is guidance. How to use them properly. How to obtain evidence properly, when they can use them without a search warrant, when they can't. And in talking with them, they've been very willing to work with this to the point, basically, if they're gathering evidence on a crime, they believe also they should get a search warrant. If it's a situation where they're looking to, somebody's life could be in danger or property could be in danger, again, there's the circumstances that search warrant can take days to get sometimes, if not, but they need to use it right away to have that authority to be able to use them without having to worry about a search warrant. And at that point, they'd be there legally, so they would happen to run while they're looking. Same way now, if you're trudging through the woods and you find a grow operation while you're looking for a lost child, that is accessible in court even though you're on somebody else's property. This would be the same type of deal, where you're searching for somebody, you have a reason you're searching for it, and you run across it, it would still hold up in court. But if they're just out goofing around and playing, that'd be another story where and the bill addresses that, where the information would not be able to use in court. And it goes back to why we need this. When I'm patrolling, when I was a deputy or as a police officer, when I would be driving down the streets, I was on public property. In everybody's front yards, I could see what's going on there. Sometimes you'd see the kids all playing. Sometimes you'd see people all grilling in their front yard. There is no real expectation of privacy if you don't have a privacy fence up. You can see the front of your house. What's in your backyard, that's another story. There is an expectation of privacy in your backyard. What bothered me last year, when I put my original bill in, I was contacted by a number of line officers working the roads. And it shows me the importance why we need to get some guidelines set up. Because I had officers contact me, they were mad because I offered this bill, because they wanted to be able to sit back in the squad room and fly the drone to patrol. Be able to fly over somebody's backyard. Be able to fly wherever they wanted to patrol the community. And that did bother me because I believe that's in violation of their expectation of privacy. And that's one reason I brought this bill forward, with some changes in it to make it better and to make it more workable and make the guidelines even a little bit stronger. We've had the situation, and it was addressed a little bit in the Public Safety Committee, where we've had a number of flyovers by the military drones or the U.S. Border Patrol drones, and there's been 20 of them where information has been obtained and given to law enforcement. Did they have authorization to use them? Because they were guarding the borders, so it's understandable, but they found a number of grow operations. I don't know if that is included in the 20 we know that have been requested by law enforcement across the state of Minnesota, but a couple of years ago, the law enforcement was contacted, given the opportunity to use the government drones for law enforcement purposes, and we know there's been at least 20 of them that have been done. All right, and we don't know which departments had used them. So it's, because of what's going on, I felt that we need to get some guidelines and how guidelines set aside so that they are used properly. I don't want a situation that happened with quite a few years ago with the FLIR, a forward-looking infrared that was used on helicopters to look for heat from a grow operation for marijuana. I believe that some departments may have overused that and to the point of abuse, and now it's required, search warrants are required to use a FLIR on a house at this time, or any other building. So you're having more information put forward. What I'm concerned about, if we don't get some guidelines in, this tool will be banned by use for law enforcement. I don't want that to happen, because it can be a good tool for the safety of the officers, the safety of the community, and a good tool to actually put the dangerous people behind bars where they need to be. Another situation where it could be used is in a standoff. I've been involved in a number of standoffs, and at least one, if not more, where the individuals end up being taken out by law enforcement. It's not a good experience going through that. And I've been sitting for 4 hours outside a house at 20 below, standing behind a tree, trying to make contact with the person. If we would have had the drone capability had been available at that time, we could have flown the drone up to the window, looked in, and see him, that he's been deceased for a number of hours because he had taken his own life. And in that situation there, we did have a couple officers get frostbite because it was, like I said, it was 10 below that night, and we were outside for 4 hours just trying to make contact before we did a forced entry. So with that, I'm up for any questions.
Questions for Representative Johnson? Seeing no questions, are there any members of the audience in attendance who wish to be heard on Representative Johnson's House File 1994 as amended? Mr. Franklin, please introduce yourself for the record.
Mr. Chairman, members, Jim Franklin, Minnesota Sheriff's Association Executive Director. Be very brief. Representative has covered all the reasons we want guidance. We think this does that. Number two is we want to be able to preserve evidence and do it correctly so that we can either bring the appropriate charges or exonerate the person who might be indicated or an allegation filed against them. We believe this bill does that, and it keeps the balance between the privacy issues and the necessary tools for law enforcement to move forward. Currently, drones are not being used. We're looking forward into the future a little bit. The handful of cases that I know that they have been used on, it's either been in Department of Homeland Security related apprehensions or lost person kind of uses, all of which would fall within this category currently. So with that, I'll conclude my remarks.
Thank you for your testimony, Mr. Franklin. Any questions for Mr. Franklin? Seeing none, then any other members of the audience? And not seeing any, then Representative Johnson has moved that House File 1994 as amended be re-referred to the Committee on Judiciary, Finance, and Policy. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you, Representative Johnson. Representative Atkins is here. Representative Atkins, Chair moves House File 2288, law enforcement required to use a search warrant for cell phone tracking, be referred to the Committee on Judiciary, Finance, and Policy. Representative Atkins, you have an author's amendment to A1.
Is it A1 or A4, Mr. Chairman? I see it quoted as A4 in the...
A4 then, Representative Atkins, thank you. The Chair moves the A4 amendment in order to get the bill in the shape the author desires. All in favor of the A4 amendment signify by saying aye. Aye. All opposed say no. Motion passes. Representative Atkins, to your bill as amended, and specifically what were the changes in that amendment?
Mr. Chairman, the effort, I speak, by the way, on behalf of myself and Representative Holberg in bringing this bill forward. We appreciate the committee's attention. What the amendment does was designed to address some concerns that law enforcement raised in Chair Paymar's committee a few days ago. I don't think we're quite there yet. I appreciate House Research's efforts to work with us. We took copious notes of what law enforcement told us at the previous hearing and tried to address that. For example, as both Chair Paymar and law enforcement officials raised, they wanted in situations that qualified not as felonies but in certain lesser offenses, for example, in domestic violence offenses, that there was an exception with respect to that. And then they also expressed a concern about how the interplay between the rules for delaying notice to the individual whose cell phone is being tracked, that they were concerned about the interplay between the statute and Minnesota Rules of Criminal Procedure, Rule 33.04. So we in the language of the amendment, it indicates that noting that there needs to be that connection between this law and Minnesota Rules of Criminal Procedure, Rule 33.04. I commend our law enforcement folks. They've indicated that they don't completely oppose this. What they're trying to do is make sure that it works in the real world. And, Mr. Chairman, the point of this legislation is that when you tell people that this device that they carry around with them, how many of you carry one of these with you? Just out a quick show of hands. It obviously is, other than Representative Winkler, people are shocked that the government has the ability to track these devices without your knowledge. There's an expectation that you have some level of privacy when you carry around a smartphone device with you. I'm not suggesting in this legislation, no one is, that law enforcement, under the right circumstances, shouldn't still be allowed to track your device and follow you around. It just says you got to have a search warrant to do it. And when Minnesota law was written 25 years ago, unfortunately nobody knew about these things yet. It was probably in Steve Jobs' head or something like that, but nobody was carrying these devices around. So what we've got, back then we had wiretaps, and we had, if law enforcement was seeking access to electronic communications, they were required to get a search warrant. That's what this does. It simply requires that law enforcement get a search warrant if they're going to follow you around by tracking your device. So for a search warrant, you need things like probable cause. It's no different than for a wiretap or anything else. And eventually, you have to give notice to the person that you're following around. In our language, and we've buttressed it or supplemented it quite dramatically, we originally said within 10 days of that search warrant being gained by law enforcement or by some other government agency, perhaps, that the person who was being followed or tracked needed to get notice. Law enforcement made an excellent point to us, which was that sometimes there's an ongoing investigation. We need a little bit more time than that. So we extended that to 90 days. And we also put in a provision that says they can extend it any number of additional 90-day periods, if need be, if it's an active, ongoing investigation. The absolute last thing that we want to do is jeopardize officer safety, jeopardize an ongoing investigation, but at the same time we want to balance that against people's constitutional rights, against their freedom, their liberty, their expectation of privacy. And so with Mr. Diebel's help and Mr. Neumeister, who's unable to be here, and Representative Holberg, I think we've tried to strike a balance that still allows law enforcement to do their job. They just simply have to get a search warrant, which I think if this law had been drafted today, not 25 years ago, it certainly would have imagined these sorts of devices. All it does is update that statute requiring a search warrant, but at the same time also give law enforcement the tools that they need to continue to move forward with active investigations. With that, Mr. Chairman, I appreciate the committee's support.
Thank you. Representative Atkins, are there questions for Representative Atkins? Representative Scott.
Thank you, Mr. Chair. Representative Atkins, I see that that there are exceptions to the search warrant requirement, and one of them is if an electronic device is lost or stolen. How is that handled right now? Can I just, if I lose my cell phone, can I call my company and say, can you find it for me? Or my kid's cell phone? Or I just think, to me, it seems like it could be onerous. But.
Representative Atkins.
Thank you, and bless you, Representative Lesch. Representative, we have, currently you can do that. Not all companies are going to be compliant with that, and we're not demanding that they be compliant with that. We're just saying that that is an exception to when this warrant would be required, so that government agency, law enforcement, if they're just trying to help someone find a stolen cell phone, that would be an exception to this requirement. They're not trying to track anybody down as much as they're trying to help a person find their lost or stolen cell phone.
Any other questions for Representative Atkins? Is there anyone in the audience who would like to be heard on Representative Atkins 2288 as amended?
I have another question, Mr. Chair.
Oh, Representative Scott.
Thank you, Mr. Chair. Representative Atkins, what do you see as the main differences between your bill and the chair's bill?
His is, Mr. Chair, Representative Scott, his is better. He's got a gavel up there, I don't. There's parallels, very strong parallels. I think that in terms of to the extent there's differences, I think they're relatively modest differences, but they both are aiming towards the same aim, trying to strike that balance between giving government and law enforcement the ability to do their job, but at the same time giving people their expected privacy protections.
I can't believe you didn't take the advantage of that question, Mr. Chair.
I was just basking in the glow of the adulation.
I thought it was an excellent answer, didn't you?
It was. I was impressed.
I feel like brown nosers, right?
Any other questions for Representative Atkins? Seeing none, then is someone going to testify on Representative Atkins' bill, or is someone just standing up? You are going to. Okay, he's going to testify. Please introduce yourself for the record.
Mr. Chairman, members of the committee, my name is Drew Evans. I'm the Assistant Superintendent for the Bureau of Criminal Apprehension.
Jim Franklin, Executive Director, Minnesota Sheriffs.
Mr. Chair, members of the committee, as the representative noted, we are not in complete opposition to the bill in its entirety, and really, in particular, some of the provisions looking for a higher standard of review when it comes to tracking cell phones related to criminal activities. What's very important for the members of the committee to know is that this sort of technology is extremely important to us in law enforcement when we're looking for and apprehending and mitigating criminal activity related to violent criminals throughout the state of Minnesota. It's been used, and we have numerous examples throughout the state of times where we've apprehended persons who have committed murders, violent crimes, that we've been using them while they're in a flight status to locate them and apprehend them very quickly to prevent further crimes from occurring. As noted before, what we're really talking about, there's some pragmatic concerns that we want the committee to be aware of when it comes to this particular bill as we look at implementing it going forward. As Representative correctly noted, I don't think the Chapter 626A that currently governs some of this contemplated cellular phone technology, frankly, because it didn't exist in its current form at the time it was last updated. That being said, I think the statute and the legislature at that time did a fairly good job of crafting some definitions. For example, mobile tracking device, if you look at the definition within the statute, defines it as a mechanical or electronic device used to track the movements of a person or things that it was attached to, which is really what a cell phone has become in many ways. And under that, we are currently required, based on the 626A statute, to get a court order, and a court order that is reviewed and approved by a district court judge in the state of Minnesota. The current standard of review is that is relevant to an ongoing criminal investigation, whereas a search warrant, the standard of review is based upon probable cause, which is definitely a higher standard of review than the 626A statute currently contemplates. couple things that are concerning to us about the bill, and we've noted it's now including with the amendments some qualified domestic-related offenses that we'd be allowed to apply for the search warrant under the statute. However, it's important to note that for the history of obtaining search warrants in this state, there's never been limitations on the particular type of crime. A search warrant can be granted for any type of crime if we provide sufficient probable cause that a crime is or is about to be committed, and we're applying for a search warrant to conduct a search in relation to that. So a felony, or even limiting it to simply domestic-related offenses, could hamper us in certain situations when we're trying to locate somebody that's committing a crime related to one of our activities that we're trying to look at. The notice requirement is getting closer to something that would work for us. We're concerned about notification if we're conducting an ongoing investigation related to a crime, that the notification requirement would alert that criminal that we're in the middle of an investigation related to them. And so we want to ensure that there's proper processes in place to either seal or delay that notification to the appropriate time when that would be. With the amendment, my only concern with the statute at this point, with the amendment incorporating the rules of criminal procedure, would be which notification requirement, which one controls. The sealing requirement does allow a judge to seal a warrant for a period of longer than 90 days. So if the notification requirement is 90 days, and then we have the rules of criminal procedure, my question would be which one controls in that situation. And so I'd want to make sure that that's very clear to us along the way. There's also some practical considerations with the search warrant. Our search warrant statute currently definitely is geared towards conducting a search at a particular place and time, whereas the 626A statute that governs current pen register orders and tracking orders is much more about a prospective search. In other words, we're gaining information going forward, that we're searching this on an ongoing basis until we achieve the objective of the particular order. So when we've looked at this for mobile tracking orders pursuant to a recent Supreme Court decision, it's been very difficult pragmatically to draft a search warrant under our current search warrant statutes to draft an order that we believe is going to be sufficient going forward. So I'm using these comments basically trying to relay to the committee that the 626A statute is definitely designed for prospective information gathering, whether it be on a pen register order, looking for incoming and outgoing phone numbers, whether we're conducting a wiretap operation, or whether we're conducting mobile tracking through one of these, and that statute's definitely designed for that purpose. And incorporating a probable cause standard with maybe a filing requirement and notification that would alert persons that we're conducting this would be preferable to us in law enforcement. Anything else?
Mr. Franklin, did he cover it all?
Hard to improve upon. Yes. Mr. Chairman, members, he's done a very excellent job, and I will not try to go back over and repeat. I agree with everything he said. I would like to just add one or two other points that I think I'll just bring it up, and I think it's worth noting. In administrative subpoenas, we do not get location information. Administrative subpoenas, if they are used, we basically get the information about the owner of the cell phone and perhaps what number they called on the cell phone. We do not get location information. I think that has been purported in the past, testifiers, and that's not what we get. The other part that I think needs some clarification, one of the testifiers earlier alleged that we were using this to get all kinds of some search warrant information through administrative subpoenas, and when he cited his examples, I went back and looked at them. All of the examples that were cited are through the alcohol gambling, using the alcohol gambling statute that the legislature gave to us. And we followed those particular rules for requesting that data under those statutes because that's what we had. And it was kind of presented that this was information that we law enforcement were using. And I think that deserves some clarification because looking at those examples, they were what was prescribed by the legislature using the statutes given to alcohol gambling. And I think those are just some clarification points. We welcome this clarification. If we don't do this right, we lose the evidence in court. And that's paramount to our importance of doing it right to preserve the justice system and make sure that what we do is proper and we do it correctly for the citizens of this state. So we welcome this. We do have some concerns. We want to continue to work on this, and we hope that in the end we can get clarity. But the statutes and some of the ways they are written and the difference between the criminal procedures that we follow and the statutes are of paramount importance to us. With that, I'll conclude.
Thank you, Mr. Franklin. Representative Rosenthal.
Thank you, Mr. Chair, and Mr. Franklin and Mr. Evans. I'm working on a bill right now that extends the time where you can search for a person on domestic assault or stalking without a warrant. How does this interfere with that, or how does that play out with this provision?
Mr. Evans?
Mr. Chair, Representative, I do think with the amendment, I think the qualified domestic-related offense, it would cover that. However, there are other misdemeanor offenses that would not be covered now under this particular bill.
Any other questions for the testifiers? Representative Newberger.
Thank you, Mr. Chair. Quick question. This came up in a previous committee as well, and I just want to reiterate this for those that are here, and then I also like to make sure that we cover this. This in no means applies to any federal law enforcement agencies. Is that correct?
Mr. Evans?
Mr. Chair, Representative, that's correct.
Thank you, Mr. Chair. And then
Newberger?
I was curious, what is to prevent a state or local law enforcement agency from doing an end around? You simply go to a federal agency and say, where is this guy? And what is there any kind of built-in safeguard there, for lack of better words? Just kind of bring me up to speed on this.
Mr. Evans?
Mr. Chair, Representative, well, a couple clarification points. So even under 626A right now, there is a gross misdemeanor violation in place if we violate and we were to do this and not follow the law as is. So we currently get a court order as noted when we're operating, even under current law. Many of the counties and the jurisdictions were already incorporating into this order probable cause based on the judiciary within that district. For the question related specifically to the federal government, there needs to be a nexus to some sort of federal crime. And so they would need to agree to assist based on some nexus that they would be examining related to the same crime. They simply would not assist us on a local crime if that's what we're investigating.
No more questions. Thank you.
Thank you, Representative Newberger. Any other questions for the testifiers? Seeing none, then the Chair renews his motion that Representative Atkins, House File 2288, as amended, be referred to the Committee on Judiciary, Finance, and Policy. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you, Representative Atkins. Members, the next bill up on the calendar will be my own House File 2553. I will present it from the Chair. We have Mr. Ben Feist of the American Civil Liberties Union. I also have an author's amendment, which is the A2 amendment. And if I could have Mr. Green, are you in a position to describe what the amendment is? I'll have Mr. Diebel explain what the A2 amendment does.
Mr. Chair, members, the A2 amendment combines the current bill, 2553, along with Representative Lesch's unmanned aerial vehicle bill, with some modifications to that bill. So section on page 1, line 1.3, this begins the substance of House File 2552 as amended within this document. Some of the amendments include a change in the definition of unmanned aerial vehicle, starting on line 1.17. And this definition is taken from Representative Johnson's bill. The only difference is that Representative Johnson's bill describes unmanned aerial cameras, because of drafting and consistency purposes, the decision was made to keep it as an unmanned aerial vehicle as originally drafted in Representative Lesch's bill. Another change was that on page line 1.24, we dropped the reference to Chapter 626A, search warrants, and that was the same change that was made in Representative Atkins' bill. Underneath exceptions, which begins on page 1 but carries over to page 2, there are some additional exceptions added to the Lesch drone bill. Starting on line 2.5, the exception for terrorist attacks, which was taken from Representative Johnson's bill, is incorporated into this version. Also, there is an exception for governmental use of an unmanned aerial vehicle for non-law enforcement purposes, and this is in response to the University of Minnesota's request to have some authority to use drones, but the authority is limited by a strict prohibition on the use of the intelligence or information gathered if acting under this exception. The remaining difference between the Lesch bill as introduced and as incorporated in the A2 amendment is a technical difference under the remedies for violation, which is on line 3.33. This language is similar to Representative Lesch's original bill, but it's patterned after Representative Johnson's remedies for violations subdivision in his drone bill. And then finally, on page 4, line 31, the amendment would extend the reach of search warrants for location information, so that's the base document that we're amending, to qualified domestic violence-related offenses. And that was the same change that was made to Representative Atkins' bill, and that was on page 4, line 31 of the amendment. And that covers the changes.
Mr. Debo, can you describe the change on the reporting requirement between this bill and the Atkins bill with respect to data?
Mr. Chair, are you referring to the differences between your location information reporting requirements or the drone?
Well, on the location information, Mr. Debo, because we have this letter from the CTIA. AT&T talked to me yesterday, and they have some. My understanding is they have some issues with Representative Atkins' bill with respect to the reporting requirements contained therein, whereas this bill has the data section reportable by court administration.
Yeah, Mr. Chair and members, the Atkins bill puts the responsibility on the telecommunications providers or electronic communication providers to do the reporting, whereas your bill takes an approach where when an entity applies for a search warrant, the court needs to keep a record of that and then submit the information to the state court administrator. Likewise, your bill requires an entity that exercises their emergency authority to access location information to notify the court after they've done so, and that also creates a record that the court would then run through the state government as opposed to the private entity.
Okay, and members, the point of this was so that we know how this technology is being used and that we can track it. If, government is tracking the people get to track government. That's the whole point of it. The court administration has indicated that there would be no fiscal note on this because it would be a minimal task that they're already doing. That being said, Mr. Feist, first, are there any questions from members regarding the differences? Representative Russo.
Thank you, Mr. Chair. And I was in another committee during Representative Johnson's bill. On line 1.19, the definition of unmanned aerial vehicle uses aerodynamic forces to provide vehicle lift. So is it your intention to exclude vehicles that would be lighter than air vehicles but could still be unmanned robotic vehicles that could collect the same kind of information?
Who are you asking that of, Representative Russo?
You.
Is there,
Because an aerodynamic force is helicopters and airplanes.
are you looking at 2553, Representative Russo?
I'm looking at the A2 amendment to 2553, which is what we're on right now, I think. Line 1.19.
So, Representative Russo, I'm not a scientist, but
Yep.
in my
I am, sir.
experience.
So aerodynamic forces would not include hot air and helium-filled devices that would also be able to fly robotically and collect information. And I think at this point, we're at the point in technology where a reasonably clever 12-year-old could probably put together such a device.
Well, is this your area of science, Representative Russo?
Physics and chemistry teacher and an engineer, yes.
Okay. Because I've been told by someone else that it would qualify based upon the lift science of even a hot air balloon and how it's shaped. If that's not true,
Well-
then it is the expectation of the chair that it would qualify for those if someone can't float a balloon into your window.
Perhaps,
So-
excuse me, Mr. Chair.
Representative Russo?
We might want to check on how the term is used specifically in aviation, and Representative Anderson's not here. In physics, the word dynamic implies a different thing, that a lighter-than-air device would not be an aerodynamic device, but it's possible that the term is used differently within the field. So,
Well, that's why we have these committees, Representative Russo, so we can find that out from smart people like you. So that's something we'll take a look at in the future, because we wouldn't want that exception. Any other questions pending that? Seeing none, then, Mr. Feist, please introduce yourself for the record and begin your testimony.
Thank you, Mr. Chair, members of the committee. My name is Benjamin Feist. I'm Legislative Director for the American Civil Liberties Union of Minnesota. I want to thank, first off, Representative Johnson for his work in the UAV area, as well as Representative Atkins. I think we're all working toward the same goals here, and the idea with today's amendment is really to get a comprehensive surveillance bill together that deals with these issues. The UAV and cell phone tracking issues are two of the three main privacy concerns that the ACLU of Minnesota is working with now. The other is automated license plate readers, which this committee has already dealt with, and this body has passed on for the Senate to now take up this session. We believe that this is a really important update to Minnesota's outdated privacy laws on these emerging technologies and dealing with privacy rights that we have expectations of under the Fourth Amendment. Currently, these bills allow law enforcement to use the emerging technologies while providing a real balance for civil liberties. And I'm not going to take a long time to talk about these bills today, because the issues have largely been covered by the previous authors and testifiers. I will add that Minnesota is not alone in dealing with these issues. For location tracking, Maine and Montana have already passed legislation that's very similar to what we're looking at today, and Utah, New Hampshire, South Carolina, and Maryland have similar legislation pending. In terms of UAVs, 9 states, Florida, Idaho, Illinois, Montana, North Carolina, Oregon, Tennessee, Texas, and Virginia, have all passed drone legislation, and at least 20 more states have legislation pending. So this is clearly an issue that's coming up nationally. I also believe there's some work at the federal level to address these concerns. As has already been identified, I'll just speak briefly to some of the main changes in this bill compared to the others. In terms of location tracking, we do have an extra requirement for the emergency exception In those cases, we expect that law enforcement could, within a reasonable time, be able to report to the courts that they needed to take warrantless action, and that's just an extra level of transparency. And similarly, as has been discussed, we do believe that a reporting requirement through state court administration would be the best way to go to make sure that the public and the legislature is aware of what's going on with these technologies. And we are continuing to work with MnDOT and the University of Minnesota to address their concerns about educational research and sort of aviation and traffic management uses that could come up in the future. We've had interesting discussions as soon as this was brought up, and we continue to have those discussions. We're also open to working with law enforcement to figure out a workable pattern, just as they have on some of the amendments to the Atkins bill. And with that, I'm open to any questions.
Thank you, Mr. Feist. Questions from Mr. Feist? Seeing none, then I wonder, Mr. Feist, if based upon the recommendations of Representative Yaruso, striking line 1.19 would cause any issues with respect to the rest of the bill.
Mr. Chair, members, I don't believe it would.
Okay.
Do I need to reconsider the entire amendment and then amend that and then redo it, or can I? Huh?
That's what. Okay, so since we haven't voted on the A2 amendment, the chair would move to amend the A2 amendment by striking line 1.19. Any discussion? Seeing none, then all in favor signify by saying aye. Aye. All opposed say no. Motion passes. Any other members of the audience who wish to be heard on House File 2553 as amended, please come down and introduce yourself for the record.
Mr. Chairman, members, Matt Ealing with the Minnesota Coalition on Government Information. Thanks for making time for us to testify this morning. Our group's primary focus is government transparency, and as such, we're going to limit our comments to the reporting provisions of this bill. We strongly support the decision by Representative Lesch to include reporting requirements in this bill, whether the subject is drone aircraft, cell phone tracking devices. These are novel technologies that the public has raised pointed questions about in terms of their use. And these questions are only going to grow over time as these devices become smaller and cheaper and proliferate in their use. And in order for the public and for this body to have to make determinations about their use, it's necessary to have accurate information about the nature and scope of those uses. So this bill includes provisions that require the creation and submission of reports that are public about device use, including such things as the number of times devices were used, legal thresholds for their use, and so forth. This bill, as amended, would require law enforcement agencies and the state court administrator to undertake such reporting and to post final reports that are public on their websites. Now, the reporting on the use of surveillance techniques has a long history in the United States, and I think we should draw that out. For instance, the current provisions of federal law that govern wiretap procedures, in 1968, they added reporting requirements to those kind of provisions. And so to this day, everything from federal agencies to county attorneys' offices, they have to report how many times they're using and the nature of how they're using some of these wiretap authorities. And subsequent to that 1968 decision, a lot of other federal laws, state laws as well, have been amended in terms of surveillance reporting. 626A.17, I believe, has provisions currently about Minnesota wiretap reporting. I'd further note that at the federal level, some of the counterterrorism provisions passed after 9/11 contain such reporting, but there's a lot less specificity than is in this bill. That's why we like this bill so much. I think if you look at some of the controversies that have been raised about surveillance authorities post 9/11, if you look at the reporting requirements for things like Section 215 of the Patriot Act, which was used as the legal basis to capture the mass mass call collection records by the NSA. There's no public reporting requirement in that provision. Here, there's public reporting, and we think that's very essential to make that differentiation. So in sum, we think that this is the reporting requirements are sound. We support them, and I'd like to make ourselves available for questions.
Thank you, Mr. Ealing. Is there questions from members of the committee for Mr. Ealing? Seeing none, then thank you very much for your testimony, Mr.
Thank you.
Members, also, there was a recommended amendment to the A2 amendment by Mr. Gemberling that you have in your packets marked as the A3 amendment. And they're technical, and Mr. Gehring, is this your? Mr. Gehring can explain what the amendment does.
So, Mr. Chair, members, the A3 amendment does two different things as recommended by Mr. Gemberling. So, on the change on line 1.2, where you're adding a notwithstanding subdivision 6, paragraph B, is sort of a conforming change to reflect that some of this data is considered criminal investigative data, but there is still an allowance in the bill for a person to give written consent to disclosure of data that's been collected. And so this notwithstanding sub 6 just makes sure that those two pieces work together correctly. And then on line 1.3 of the amendment, the notwithstanding sections 138.163 and 138.17, that's chapter 138 is this chapter that deals with the Historical Society and state archives. And this section clarifies that data collected from one of these vehicles isn't included as part of the historical record of the state.
Any questions for Mr. Gehring? Seeing none, then all in favor of the A. Oh, Mr. Johnson, Representative Johnson. Okay. So the A3 amendment amends the A2 amendment. Okay. Just to be clear, the A3 amendment also amends the A2 amendment, which is delete all. No, it's not delete all. It's just amend. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. So that is now in the A2 amendment. Members, I would note, is there any other members of the audience that wish to be heard on House File 2553? Representative Johnson. Before you go, Representative Johnson, I want to make two other explanations as to the point of these changes. The adding on of the drone bill language 2552 to the cell phone tracking bill 2553 is because we had heard that the Senate kind of wanted to hear it all in one bill rather than sending them separately. So we were trying to be helpful. Since then, we thought maybe that might not have been the case, but this is our intention to reduce or streamline the process so it's easier. The second thing I wanted to say was that the University of Minnesota stated concerns about their current drone program have been incorporated into the bill as an amendment, so their concerns are addressed in here. I did not address speculative concerns. So agencies that came forward, like MnDOT, for example, saying, well, we might do something in the future on drones, so don't do this. I didn't address those because it's speculative and I don't deal with speculation. If at such point they need changes, then they can come forward just like any other agencies and ask for the exceptions to be drawn out. That's why I didn't include it. Representative Johnson.
Mr. Chair, I just have a couple questions on this bill. You have the reporting requirements. Does that mean that any time one of these unmanned aerial vehicles is used, it's going to be required reporting?
Well, Representative Johnson, that reporting requirement was originally for. Why don't I let who can explain? Mr. Diebel. Why don't I let Mr. Diebel explain it better?
Mr. Chair and members, the bill is drafted with the intent of capturing each time an agency uses a drone and have them report on it.
Okay, Mr. Chair.
Representative Johnson.
I've actually tried to fly some of these radio-controlled vehicles or unmanned aerial vehicles. It takes hours and hours and hours of practice to be proficient at it. So the reporting time just for practice is going to be unbelievable. The majority of the times these are going to be used is just going to be for practice, just because the ability and the amount of time and the experiences and the expertise of the operators can make it very difficult for, I don't know how many are going to want to keep logs and reporting just to go out and practice to keep up proficiency at it.
Duly noted, Representative Johnson. I believe you on that. And those who fly drones in the military are all pilots. They don't let folks come in and just fly drones. They have to be certified pilots. Mostly, they have logged a lot of flight time to do it. So, I will take a look at that and see if that meets with our intent based on your suggestions. Okay. Any other questions from Representative Johnson?
Then I also have another issue I'd like to take up with you on this bill. It deals again in the data retention and classification. On lines 3.6 to 3.7, the estate data must be deleted as soon as possible in the event no later than 24 hours after collection. It deals with if something is captured that wasn't in the search warrant. I, as an officer, be sitting in court, I know what it's like when the defense attorney goes after you because your camera in your squad car malfunctioned and there's a dead spot. Or it's shut off on it by accidentally bumping the button on your control. And you don't notice it right away, and you have even a 5-second stop in the recording. Generally, that evidence is thrown out of the court because they can speculate and make the judge or the jury believe that you're hiding something. Now, you start deleting evidence off this tape and having blank spots, I don't think there's a law enforcement agency that would ever use it just because of the way this is written. And that's taking the tool for the safety of the public and the officers away because of that deleting responsibility that you have in your bill.
Understood, Representative Johnson, and you did bring this up in public safety as well. Stated the reason for that is innocent individuals should not have their personal information exposed if they are not the subject of a warrant. I think that has substantial civil liberties implications and privacy implications as well, even if we're not talking about the government part. But I note your concerns about that, and also you've consistently had this concern as well with last year with the LPR retention as well, and I think I understand your concerns about that from a law enforcement perspective. But I'm going to keep the language the way it is in there for now. We can have ongoing discussions about it. Anything else, Representative Johnson? Okay. Any other questions? Representative Portman.
Thank you, Mr. Chair. Was law enforcement intending to testify for or against your bill, or do you know where the law enforcement community is on your bill as amended?
Well, I think last time I heard them say that they like Representative Johnson's a little bit better than I liked mine, but are you going to testify on this or sit with this one out? Mr. Franklin, do you want to come up? I don't want to put you on the spot if you don't want to.
Mr. Chair, I would appreciate knowing where the law enforcement community is because it will determine how I vote on the bill.
Mr. Chairman, members, we're trying to be a team player here today, and we do have concerns about the bill. We do have some concerns about the timelines that have already been talked about. We've heard a reference to the NSA and what the NSA is doing. That's not what we're doing in Minnesota under any rule at all. The reporting requirements, again, as I stated earlier, we're concerned about that. If we have inconsistent reporting requirements that we currently have under the criminal rules of procedure, we're going to have double standards here, and sooner or later officers are going to be making a mistake. So we prefer conformity, uniformity. We want to do it right. And we're looking for guidance here. We want to continue to work on this, but we do have some concerns. But we do think it's an important emerging topic that does need to be addressed. That we do concur on.
Representative Portman.
Which committee are you going to next with your bill?
We're going to Judiciary, Representative
Okay, big fun. See you there.
Any other questions? Seeing none, then all in favor. My motion is that House File 2553 as amended. All I need to adopt the A2 amendment. All in favor of the A2 amendment, which we've been talking about this entire time, signify by saying aye. Aye. All opposed say no. Motion passes. Then to House File 25-3 as amended by the A2 amendment, that it be referred to the Committee on Judiciary, Finance, and Policy. Signify by saying aye. Aye. All opposed say no. Motion passes. Thank you. The last bill that I have today, members, and we're a little bit ahead of schedule, which is good, is House File 2552, which is only the drone part of the bill, which you've already heard and has passed. So, do I need to? What does it do? Okay, right. So I do have an amendment to House File 2552, and this makes the change that allows government entities like the U of M to do it for their research as long as the data is not usable in court. So that compromise was struck between the ACLU and the U of M, and I believe we have agreement on that. But I think it needs, Representative Pugh, I think it needs to be passed out. So it's being passed out now. You can take a look at it. But it does the same thing that we did in the larger A2 amendment in 2553. Okay, and at the top, the amendment is mislabeled as 2882. It should be 2552. Help her pass those out. You got to move. Huh?
Mr. Deeble has a good point about how we can properly amend this.
Okay.
This is the language, but the amendment's not.
I mean, was there? Okay, so we'll. Okay. Oh. Representative Simon, are you ready to go on House File 859? Representative Simon, are you ready to go on your House File 859?
Mr. Chair, the sort of essential testifier was here earlier. He's not here now. I can try to track him down.
If you could, I'd just like to make sure that this bill is clean. Representative Hortman.
Thank you, Mr. Chair. I'm sorry I wasn't paying close enough attention. Whose amendment is this, and is it your intention to move it?
It is my amendment. Mr. Deeble just informed me that there are other changes that I may want to incorporate. However, I think what I'll do at this point is, because of time considerations, I will probably just move the amendment as is and have it be missing some of those other nuances. But make sure that we include the language that takes care of the U of M and their research, and then move this along, since we already have another bill that does what the committee has intended. So,
Mr. Chair, then I have a question for you about the amendment. I think what it does is it creates a lot of unintended consequences. A situation that would fall under this amendment would be if you had if you were surveying wetlands in a county. Let's say you're in Anoka County, where I was born and raised, and the county is gathering data as to where the wetlands are located and monitoring them over time. If they were to discover through information that they gathered that somebody's draining one or put a big pile of dirt by one so that it could slowly erode over time and fill in the wetland, under this paragraph, you're saying that that information couldn't be used in any sort of regulatory proceeding unless the landowner consented to it. I think that's just one I can think of real quick, but I wonder if there's a lot of things that you're pulling in here that then regulatory action can't go forward And under current law, it could. I don't know if you want it to be this broad.
Okay. Well, Representative Hortman and members, I do, because until I hear from the DNR or a watershed district that somehow gets their hands on a drone or something, I think that the standard should be protecting privacy interests and property interests. When the DNR comes forward and says, you know what, we really need this as a tool, they should get the stamp of approval of the Minnesota legislature to do that. The U of M has come forward and said, we use this now for research purposes in the School of Aviation, and so we want this exception drawn out. So we crafted the exception. If for some reason the DNR looks at this language and says this is going to completely make it impossible for us to effect an administrative action based on drones, which I don't think it would, because frankly I think they could find out this is the case and then get separate approval to do it. But if that were the case, then they could come through this body and get that carved out as an express exemption for them. I expect that over the course of the next few years, we probably will hear from some people that want to start using it again. So just to answer your question, it is my intention to be that broad. Representative Portman?
Mr. Chair, would an unmanned aerial vehicle include all satellite imagery then?
Under the definition that was passed, no, it would not include satellite, because the satellite does not use it's floating around.
Mr. Chair, I still think that it's ill-advised to go forward. You know, the way you've described it is, let's protect data first and figure out what the negative consequences are later. It seems to me, over the 10 years that I've been here, when the legislature looks at a very clearly defined problem, where somebody comes in and says, here's where my data has been taken and I don't want it, and there's a problem, and we look at a harm that's occurred and we try to solve that, is where we do our best policy making. I think when we're trying to be proactive, it's very dangerous for us, and we often find ourselves creating bigger problems than the ones that we're trying to solve. And I think that the way that this particular amendment is drafted is very broad and could get us into all sorts of areas that we're not imagining right now. So.
Okay, well, I'm certainly willing to move forward on it without the amendment. It actually provides the governmental entity with more permissive use than the existing bill, but I'm willing to drop it. So if any other questions or opinions of the committee? Representative Scott?
Thank you, Mr. Chair. I think that's something that you can probably add in judiciary as it goes to that. If you get some language that is a little more agreeable to everybody and tightens it down where it needs to be tightened and loosens it where it needs to be loosened,
sure,
maybe that'll work.
Okay.
Right now, maybe it's not the best thing.
Thank you. Any other questions? Now, we just had the same bill as an amendment in 2553, but if there's anyone who wants to say anything new just on this bill, feel free to come down. Seeing none, then Chair moves that House File 2552 be referred to Committee on Judiciary, Finance, and Policy. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Members, due to your profound efficiency, okay. So we can take up Representative Simon's bill, which was intended to be after lunch. Representative Simon, Mr. Elwood is here. Are you ready to go?
Yeah.
Representative Simon moves that House File 859 be referred to the Committee on Judiciary, Finance, and Policy. And he has with him, you don't have an amendment, is that right, Representative Simon?
That's correct.
And Representative Simon, to your bill.
Thank you, Mr. Chair and members. House File 859 is really step two in a step that I and others took. I think it was in the 2007-2008 session when we as a legislature with bipartisan support passed a bill that allowed victims of domestic violence to get out of their residential leases. And for the first time ever, we set forth the criteria for doing so. And that's worked well, but there have been some glitches on the way. And this bill is the product of a lot of hours and a lot of work by a lot of stakeholders. and I'll be the first to tell you, as Mr. Elwood will in more detail, that we're not there yet in terms of total consensus, but we're awfully, awfully close. So I'm going to hand it over to Mr. Elwood to describe the particulars, not only of the bill, but where the ongoing negotiations are, and they are awfully close to consensus.
Mr. Elwood, please introduce yourself for the record.
Mr. Chair, members of the committee, Ron Elwood with Legal Aid. First, I want to thank Representative Simon for carrying this bill this year and the original bill that tries to give some more protections to victims of violence who live in rental properties. The last bill in 2007 that Representative Simon authored was an agreement with the Multi-Housing Association, and I know that Mr. Liljenquist, who represents them, if he thought this bill was coming up right now, he would be right here sitting next to us. He thought it was this afternoon. But so before I go into detail, just if I can just, I can't obviously speak for him, but I think we have worked closely enough and collegially enough that I can say this with certainty and confidence, that the concepts that you see in this bill will not change one iota from now until it hopefully gets to the floor for your vote. We have agreed in principle on all of these things. There are, as Representative Simon said, still some issues that we need to work through. If you want details, I'm happy to provide them for you. I can tell you that by the time this bill reaches judiciary, they will be either ironed out or they probably won't be heard in judiciary. But I am confident, and I think he would say the same. I mean, the Multi-Housing Association and Legal Aid have been committed to work together to make sure that a bill that ultimately comes before you is agreed upon by both parties, and we're committed to that ethic of working together. So with that, I would like to walk through quickly the contents of the bill.
Go ahead, Mr. Elwood.
Section 1, well, let me just say, just as the overview, here are the three things basically that this bill does. In 2007, in Representative Simon's first bill, we provided, for the first time, the opportunity for a victim to break the lease in the middle of that term if there was an imminent fear of violence. Trying to balance the interests of the two parties, we provided essentially a liquidated damages for the landlord who was expecting the lease to continue further. It was a fair compromise at the time. The mechanics of that just don't work. And so one of the things this bill does is actually make concrete and make usable the idea that we tried to put in the first place, whereas the victim can break the lease without the legal repercussions if they're in a rock and a hard place, while the landlord gets fair compensation for the loss of that, some fair compensation for the loss of that expectation of rent. That's the first thing it does, makes it more usable. The second thing it does is make it easier and quicker to get a perpetrator of that violence out of that unit if they happen to be a tenant. So if they're breaching the lease, nobody, for the protection of everybody in the building, the landlords agree they want to get that tenant out. And the third thing it does is simply say that a person cannot be evicted just solely because they've been a victim of violence. So those are the basic principles. So let me, again, now go through the bill. Section 1 makes it part of the covenants that the perpetration of violence is a breach of the lease. And connecting some legal dots, this is where it also creates the ability of to use the expedited eviction procedures that are already in current law, and now it makes this breach eligible for an expedited eviction procedure, which allows the landlord to get a bad apple out faster. Section 2 is really the guts of the bill, and this is where we change the liquidated damages to say that instead of having to come up with extra money, which is the first approach, in this situation now, the new bill, the new law would read that the landlord simply keeps the security deposit. So it's the same amount of money that was asked for the first time. It just comes from a different pot, some money that the tenant has already paid and not likely to get back anyway, and so it makes it better work for everybody, simpler. It also addresses the situation where the victims might be a sole tenant or might be living with other co-tenants. And it creates a procedure by which those conditions are addressed. It allows law enforcement, court officials, qualified domestic abuse advocates and sexual assault counselors to issue the qualifying document, which essentially is the legal document that would be required to allow them to break the lease. And then that was Section 2. I just draw your attention to Subdivision 6 on line 4.34, starting there. We had a whole bunch of definitions which make this thing work by having these other folks being qualified to submit the documents and who they are and what those documents are. Subdivision 7 on 5.25 makes it clear where federal law, for example, the Federal Violence Against Women's Act, has provisions in there that, of course, federal law trumps. But this is really comfort language because the federal law would apply to only public housing, whereas the predominant things we're doing here are in private market housing. And then the final section on Section 3, starting on line 5.29, is where the tenant, the provision that the tenant cannot be evicted simply because he or she is a victim of violence. And I'll stop there.
Representative Simon.
Yeah, just a couple of points of clarification. Thank you, Mr. Elwood. One, I just want to make sure that that members understand that because we've shifted it in this bill so that now it's the damage deposit rather than a month's rent that goes to the landlord, I want to make sure everyone understands that does not include actual damage done. So let's say the damage deposit is $1,000. That would be forfeited if the victim of domestic violence had to break the lease, but it would not stand in the place of actual money assessed for actual damage. So it would be $1,000 plus whatever the damage is. I just want folks to understand that. That was a point of agreement here. The other thing I would say, and maybe this is a little unorthodox, but oh well, so is a Friday hearing for this committee. So I want to just tell everyone what the couple of remaining issues are, and folks can either weigh in or not. But in terms of where we haven't completely met in the middle yet, there are really two, among other, two big issues. One is the issue, as Mr. Elwood said, this bill would expand the types of information that could convey that domestic violence had occurred. So it's not just a court document anymore. It could be a sexual assault counselor. The question is, should the sexual assault counselor have to attest to something under penalty of perjury, or is it okay that the sexual assault counselor, as an example, just attest to it not under penalty of perjury, but say that to the best of my knowledge, this person is in distress, and it seems to me, likelier than not, that they have suffered abuse, that sort of thing. So the question is perjury, under penalty of perjury or not. So that is one issue that we're dealing with. And then the second issue is whether or not the person seeking to escape the lease needs to inform the landlord of the name of the individual, the actual name of the alleged perpetrator, yes or no. Those are two issues where the gap has not been bridged yet. Frankly, I'd be interested if people care to comment on what they think about those things. You need not. This has another committee stop. But in case folks are wondering what is the hold-up to total consensus here, those are two of the issues. But everything else has been highly and heavily negotiated between and among the sides. And I'm just curious if members have thoughts or advice on those points.
Representative Scott.
Thank you, Mr. Chair, and thank you, Representative Simon, for clearing up the issue about extended damages, because that was a question that I wrote down. I wanted to make sure that, landlords can still recover whatever thing, if anything needs to be fixed that's broken or otherwise needed repair. As far as the finding out the name of the perpetrator, is that not already part of public record if police have been notified?
Mr. Elwood.
Mr. Chair and Representative Scott, under the new provisions, there would be now a number of what we're calling qualifying documents. Existing under current law are no contact orders and OFPs, those would automatically name the perpetrator. That's, by expanding the number of documents, this issue arose. The reason for expanding the number of documents is because we've heard repeatedly that there are a variety of reasons why it would not be safe for someone to seek an order for protection or a no-contact order. And therefore, the limitation was preventing some folks who could really needed to take advantage of the law from doing so. So we are expanding that ability to have the underlying documentation required to justify the lease breaking to court officials. So if there's any other court action that might not necessarily be those two types of petitions, or any document from the law enforcement official, those would likely name the perpetrator. So those things would already be included, the perpetrator would be named. But we're also including in this, and the Multi-Housing Association is not uncomfortable with adding these additional people, sexual assault counselors, domestic violence advocates, both of which are defined terms in Minnesota law. They have, they are all, my understanding is all of these are under some oversight from the state. There's extensive procedures and protocols that they are required to follow. So I think the multi-housing, again, they're not here, so I hesitate to speak, but we've been talking about this, for such a long time, and I think I can say that they're comfortable with the nature of the person we're asking to verify that this is in fact the case. But those documents wouldn't in and of themselves we're creating a new document, and that doesn't in and of itself name the perpetrator like an OFP. So we're trying to get to a point where we balance the interests of saying that the landlords have a legitimate right to know and important, who it is, because if it's somebody with keys, if it's a former tenant, if it's a worker, if it's a manager, if it's another tenant in the building, so they have a totally legitimate reason. The balancing interest, the competing interest, which we of course would say is equally compelling, is the safety, the well-being, the physical, emotional, and psychological well-being of the victim, who, after all, this is designed to help in the first place. So we're trying to struggle on a way to make it so that if in every possible way, if the perpetrator is known, because it could be a stranger and they don't know who it is, but if they're known, that the tenant would give that name. But we have to also just balance, well, how can we also protect the victim? So we haven't gotten the magic words yet, and that's what we're asking for some more time to do.
Mr. Chair, and so why wouldn't, if I was a victim of one of those, cases, why wouldn't I want my landlord to know? I would think that would be, and I've never been a victim of that sorts of things, but I would think that it would be beneficial for the landlord to know, to be able to watch out for this person.
Mr. Elwood?
Mr. Chair and Representative Scott, if we would have heard this bill this afternoon, we would have had some of the counselors here and who would give you a far better answer than I will be able to. But I believe that, first of all, remember, this is to allow the victim to flee the situation without having to have the untenable choice of breaking the lease and violating the lease, breaching the lease, and having all those consequences. That's the rock and the hard place. Do I stay and not break my lease, or do I go for my safety and risk all the consequences of breaking a lease? This is what this was designed for. So, the tenant is no longer going to be in that premises. And they may have, and I am told that oftentimes they do, there is a fear that by revealing that name, that could place that individual in physical jeopardy. And that is the crux of the problem right here that we're struggling with. But all I can tell you is that both sides are fully committed to trying to get there. Whether we can, I can't predict the future, but I can tell you that we've been working on this since September in super good faith. I cannot say enough good things about the Multi-Housing Association. They have been so constructive, so helpful. We have done this in the most collegial way, and we're committed to trying to make it work for both sides, and that's all. That's the best I can tell you right here at this time, at 11:32 on this, at this day, at this time.
37 seconds. Representative Scott?
Thank you, Mr. Chair. I just jotted down some notes while you were giving your testimony, and I just wanted to make it public, I guess, or most people probably already know this, but the standard multi-housing lease, if you break the law, which committing an act of violence of any kind, if you break the law, and that's grounds for termination. So if that person was on the lease, the person that perpetrated against, their spouse or girlfriend or boyfriend, that would already be a violation of the lease in terms for getting that person out. And we actually have had to allow somebody to leave under these circumstances. It was a bad situation, and the woman was pregnant at the time. She ended up losing the child because he beat the crap out of her. But I'm wondering, too, if, in cases of stalking or sexual assault, if it didn't happen on the premises and the person that did the violating was unknown to the victim, is the landlord still, if we don't know that there's any way that that person that perpetrated the crime knows where that person lives, are we still obligated as landlords to allow them to get out of their lease?
Mr. Elwood.
Mr. Chair and Representative Scott, that's why the safeguards of these qualifying documents are in there, because there would have to be the counselor or the court official or the law enforcement official. First of all, the crimes we're talking about are defined in law. That's number one. They're cross-referenced, so we're not making up new stuff. The second thing is that the tenant needs two things to legally break this lease: their own statement of that they need to leave and tell the landlord, when they're getting out, what to do with my stuff like that. But the second piece, that alone is not enough. The second piece is they have to actually go see somebody else, an independent. In fact, I think we're calling it a qualified third party. Exactly. I believe that's the definition in here. It is qualified third party. So somebody else has to verify that, and that form, if you see on page, well, maybe we're not. Oh yeah, here it is. I'm sorry, 3.22. They have to say, I have a reasonable basis to believe that these things are true. And if you see on page line 3.28, we have at least the statement in there now where the person has to say, I'm saying the foregoing is true and correct. Now, this is what Representative Simon just mentioned, that I think the landlords would want some other stronger words in there, and we're playing with those. And what are the magic words? I don't know. But the concept is the same. We're trying to make every effort to get the landlord the name. But we also have to balance that with the protection of the victim, and that's kind of where we're at.
Mr. Chair, where's this bill going next?
It's going to judiciary, Mr. Scott.
Okay, because I'm just hesitant to move it on without having everybody here to testify on behalf of the bill, as long as, I guess, and I think the both of you, as you've said, have been working in good faith with the Multi-Housing Association. I expect that would continue, and so hopefully by the time it gets to judiciary, some consensus would have been reached on these two issues, because I think they are important issues. But thanks for the bill.
Representative Pamar.
Mr. Chair, just to clarify, Representative Scott, I don't. If I read the bill correctly, it's not just that someone committed a crime. In other words, there's an arrest record, but if you have a civil order for protection, you haven't actually committed a crime. Civil proceedings, so you'd have an affidavit from the civil court giving the order for protection. Is that right?
Yeah. Mr. Elwood?
Mr. Chair and Representative Pamar, that is correct. I probably was just too broad brush on that, but you're right.
Representative Pamar?
No.
Representative Newberger?
Thank you, Mr. Chair. Just two quick questions. As we go through on line 3.19, this form that will be filled out it's very similar to transport hold form that we use commonly in the emergency services to take people against their will if they are a threat to themselves or others. That's a whole other discussion, but I'm very familiar. This is a close cousin to one of those, in my opinion. And as I read through this, I'm just kind of playing out some scenarios in the future as how this would work. Starting on 3.18, I, the name of the third party, do hereby verify as follows, that I am a licensed healthcare professional, a domestic abuse advocate, as the term is defined, or a sexual assault counselor, as is defined, and I have reason to believe. I think this language might need a second look here. First issue I have is I'm a licensed healthcare professional. That's a very broad spectrum. I could be a licensed doctor of podiatry. I could be a chiropractor. This whole, I am a licensed healthcare professional. I would like to see this tightened up a little bit as this bill takes its course through the committee process. The domestic abuse advocate, that's clearly understandable. The sexual assault counselor, that's clearly understandable. But my question to you is, why is law enforcement not allowed to sign one of these if you went to your county sheriff's office or if you went to your local police chief? Because clearly law enforcement is involved in many of these cases, and these people know domestic abuse when they see it. So I would like to, first of all, I would like to see the language tightened up on the licensed healthcare professional. That's a broad brush that paints the entire planet. And then I would also like to know your opinion on adding a law enforcement component to this. That's the first question that I have.
Mr. Elwood?
Mr. Chair and Representative Newberger, I think on your first point, the healthcare professional, we did talk about that it is broad. On the other hand, I think we feel, if somebody walked into a podiatrist's office, I doubt a licensed podiatrist would sign something like this because they have no capability of verifying that. They're saying that I have a reason to believe this, and I'm signing that this is true and correct. I don't think we think that no medical professional who is not qualified to do that would do that. But we're happy to get better language if that exists. So we'll take that under. We'll keep talking about that one. And as far as your second point, as far as law enforcement, actually, it's confusing. It's new language, but is that already in the bill? I draw your attention to line 5.19, where we have the section of. So the form that you're seeing on 3.19 that you referred to is only one of a number of qualifying documents.
All right.
And another qualifying document back there on 5.19 is the law enforcement documentation. So that is already in there. We have already taken care of that. It is a little confusing because these two things are in two different places in the bill. I appreciate that. We struggled with the drafting and the construction. This is what we came up with.
Representative Newberger?
Thank you for that clarification. I think just to speed things up, I think that somehow merging these two, 5.19 to 5.23, somewhere within the 3.18 section, it might clarify a few redundant questions. The other question I have is this: is in my professional experience over the years, I have an acute awareness of many of the low rent and the high crime neighborhoods throughout the western half of the metropolitan area, and it is not uncommon for the many of the rental units where you have the landlord who lives upstairs and you have the renter who lives downstairs. So how would this bill address the issue if the landlord is the abuser?
Mr. Elwood?
Mr. Chair and Representative Newberger, That's the same issue that is exactly the same as it is today. So we have not heard, I mean, our practice at Legal Aid is unfortunately, it's quite busy with these issues, unfortunately. And we have never heard of an issue where that has created any problem. Neither we've heard anything from the domestic violence advocates or the, those folks. So, and it's current, it's the way it is now. So that's the best I can say.
Representative Yarusso.
Thank you, Mr. Chair. First of all, I really appreciate the fact that the provisions in this don't wait for a crime to have occurred, because if one of my kids was being followed home from the bus every day, so that person is finding out where they live but is managing to evade being, if the police are brought in, I wouldn't want to have to wait till they were actually attacked for them to be able to move. But on the question of the healthcare professional thing, I've had a professional engineering license in the past, and in that kind of professional licensure, you're specifically prohibited from practicing outside your area of licensure and your area of expertise. And so I think a quick check on whether that's the case for the medical professions, I think, would settle whether or not that language needs to be amplified there.
Thank you. Representative Johnson.
Mr. Chair, Representative Simon, well, thank you for bringing these issues forward, because they are important. I'm probably one of the few here that actually been on the scene of a very violent domestic and had to deal with the situation numerous times. That brings me to the slight issue I have and actually concern with this section in 3.15 to 3.32, the advocate being able to sign the form. The reason I'm concerned about that, if they're signing this form, law enforcement might not know about it, which means that the perpetrator would be getting away with it. I would be very comfortable with them being able to sign this form as long as there's a police report to go with it, so that it's being reported. That way, if there is a crime or in a situation like Representative Yarusso stated, somebody following their children home, which actually does fall under the stalking laws, so that would be a crime. But by having a documentation that a crime has been reported or the situation has been reported to law enforcement, I'd be much more comfortable with that, so we get a documentation and a trail going, so if there is a perpetrator or a crime happening, it can be dealt with.
Mr. Elwood?
Mr. Chair and Representative Johnson, thank you.
Any other question? Representative Paymar.
Well, Mr. Chair, I just get back to Representative Scott's question. It's the same thing. I mean, if someone has an order for protection, is concerned, the court has found that domestic abuse took place, it's not, crime is not committed, there's not an arrest report, so now if we include language like you're suggesting, albeit with good intent, then it would force that victim to then involve police when she may not want to. The civil order for protection is sufficient. She has proved she has convinced the court that she is in fear. Now you're asking her to take another step by involving the police, and she may not want to. I'm just saying that it's opening up another section here. Maybe they need to work on something like this. I don't know, but.
Representative Johnson.
Mr. Chair, Representative Paymar, that's the thing. If they had the order for protection, that would be another document that would allow that. This is just so going to the point where it's just not. He's trying to change it from a he said, she said situation to be able to get out of these leases, because if they have that civil action already, they have documentation. But this is going to point, so there's a second point of documentation available.
Any other questions for the testifier or bill's author? Seeing none, then are there any other members of the audience that wish to be heard on House File 859? Please introduce yourself for the record and begin your testimony.
Yeah, Chair. Cullen Sheehan with Lockridge Grindle Noun, and we represent multi-housing. And while I'm not prepared to answer specific questions about the bill, I can attest to the fact that Representative Simon and Mr. Elwood have been negotiating in good faith and continue, and I think that we are relatively close, and hopefully we'll be able to come to that final resolution. So I just wanted to answer your question, Representative Scott, and we will certainly keep you posted as this progresses if anything does come up.
Mr. Sheehan, were you here when Mr. Elwood was shining your apple?
No.
He said all kinds of good things about you. Just,
That's great.
Okay.
And thank you for keeping me on my toes this morning.
I do what I can. Any other questions or comments from committee members? Seeing none, then Representative Simon moves that House File 859 be re-referred to Judiciary, Finance, and Policy. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you, Representative Simon, and testifiers for being nimble.
I'll give those back to you for now.
Members, we have House File 2694, Representative Lillie, Real Estate Broker and Salesperson Regulation Modified. I told Representative Lillie we'd get to him first in the afternoon, but because of your efficiency, we have time left before our lunch break here. This is a bill that I have not heard any opposition to it at all, and I've been listening to people for a while on this now. Is there anyone in the audience other than Mr. Eager who wishes to be heard on House File 2694? Okay, I'm aware of no opposition to this bill, members. So the chair will move House File 2694 that it be re-referred to the General Register. And Mr. Eager, do you want to come down and tell us what this does?
Thank you, Mr. Chair. My name is Paul Egger with the Minnesota Association of Realtors. Thank you for moving the bill. Representative Lillie was going to be here at 1 o'clock, and you're well ahead of schedule, so I checked with his office, and he was not going to be here until that time. So appreciate you moving the bill right now. Mr. Chair, as you stated, I'm certainly not aware of any opposition to the bill. This is a project that we worked on over the summer, going through Chapter 82 and trying to update a lot of some of the language, identifying some areas, some terminology that is used commonly throughout the chapter, but for whatever reason, definitions had not appeared in the definitions section. We shared an early draft of the bill with the Department of Commerce in September. We shared our final draft 3 months ago in December. They had some minor suggestions which we incorporated into an author's amendment. In the last committee we were in, Mr. Elwood asked that we hold off on moving forward with a couple of the definitions, and we also remove those as we'll continue to have some discussions on another bill. But with that's the legislation. And Mr. Chair, I know things are moving quickly this session, and so obviously if anybody comes forward after we leave this committee or along the way, we're happy to work with any parties that may identify something. We're trying to clean up the chapter as best we can.
Thank you, Mr. Egger. Questions from members? Hearing none, that chair has moved that House File 2694 be recommended moved to the General Register. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you.
Thank you very much, Mr. Chair.
Thank you. And members, we don't have any of the other authors here. We have covered 6 bills, and we have 5 remaining, 2 of which are Representative Holberg's bills, the Data Privacy Commission, and that wonderful bulk data bill that we heard the other day. So we will do our best to get folks here by 1 o'clock to make sure we can move through swiftly. Until then, the committee is in recess. Is there anything else anyone to bring up before we take recess? Representative Scott.
Thank you, Mr. Chair. I see that Representative Moran's bill is an information only. Could you explain that? Is the bill in the possession of this committee?
No, it is not, Representative Scott.
And where might it be?
I don't know, Representative Scott. I think it just didn't get introduced on time or something. I don't know where it's sitting. It's the expectation that it will be brought up next week. We're trying to be efficient about what we hear so that when it comes up.
Okay.
Those questions will be cleared. Committee is in recess.